also taken up by your No, I have not taken up this. I am finding that the one application for there may be documents, one legal question that's in the revision. I will not certainly will not entertain. The order impugned is order dated. Order is dated 17 May 2023. Let me have a quick look. 312. Our party is only 330. 313. 312 is the order. It is a composite order. 312. It starts from 312. Their application was disposed of. Our application has been dismissed. That is at page 330. Can you take 312? Can you read from 312? Be clear from it. That should be clear from it. So 312 is a order impugned is order dated. Order dated will 17 May 2023. Are you telling? Yes. Why are you referring 312? This is a 17th May order 2023. But a certified copy is also there. This is same thing, no? Please take your seat. Let me have to. Where is the judgment of the second appeal? The judgment at page 159. Oh, this is that judgment. Yes. Only the latter part. What happened in they went up to the Supreme Court, that was summarily rejected. Dismissed as withdrawn. Number 159 and withdrawn. But we are only. I want to see the decree, sir. Degree. Yes. But we are only concerned. If you sir, let me understand. Grab the fact, bare fact first. Where is the decree? Okay. Decree in appeal. Second appeal. You must have possessed it. Page 98. Decree. Page 98. Decree in second appeal. Decree Junior Bandobadhyay. Decree in second appeal. That's why I requested my junior band whether it's available or not to find it out. You have. Right now we should have. You must have. You are proceeding with the execution case. You must have. That is there. Yes, there is a doubt about it. Drawn up. Not only drawn up. Let's say it's drawn up how the appeal can be drawn up and then that could be copy. If on that basis the occupation charges will receive. Look at what you are executing. The decree will be marked. Eviction that's been marked in second appeal decree. Yes. So in effect, you are executing the decree of the second eviction. Decree of second appeal. Yes. The permission which was granted by me in the second appeal to withdraw that you have applied for. Yes. Then you have been permitted to withdraw. That's all. Because the reaction from your two applications. One, praying, allow me to withdraw one night, and addition of yours in the execution case. Where is those two applications are? First, I have three applications. First application, your lordships kindly find. That's similar order 21, rule 97 to 100. That is at page 201. That has not yet been considered. No, that has not yet been decided. Has not yet come. Watch. You can hear the flag being like this. And then let me see what is your prayer in order 21 rule 97. Sir, you are a purchaser. You are praying determination of the legality and validity of the decree. All for the proceedings of the title execution. But my prayer is now very limited. Very limited. Now let me understand your effort. Yes, that was there, but I am not. No. I understand. I am not. This is the number one. Thank you for pointing out this one. Order 21 rule 97 by a purchaser of a share from a co-sharer of a joint.
Correct. Not a co-sharer. Co-sharer sold it to someone. He sold it to me.
Now,
kindly come to.
Let me gather the fact one, but then the second application.
That exactly I wanted to tell you.
Oh, sorry.
No, I will only give answer. I will not make submission now.
Please give me the page number.
May I?
Yes, of course.
Now, application under Order 1, Rule 10 of that is at page 298. 93. 293. 94. 294. But unfortunately, the prayer is at page. Prayer is at page 304. Instead of reading 298, kindly read 304.
These are the two applications.
No, another application is there. And that is the another application that is under 151. Your lordship will get it. The page is 302. 302. Starts from page 302. But prayer is at page 298.
That is what you have prayed for.
That is
addition. This is addition.
The petitioner, Your Honor, be graciously pleased to allow this petition to get 1/9 share of the occupational charge. But my prayer is restricted to that.
To the two applications.
One is actually, this 151 has to be read with this Order 21, Rule 101. The thing which has
that I will be inquiring from you. I have to learn from you that whether this is miscase in addition to that or midcase itself in addition to the execution. Because as soon as you have filed the Order 21 Rule 97, inviting the court to determine your whatever, and questioning the executability of the decree, whether a separate application for addition is at all necessary or not.
No, exactly. I don't think so. It's required.
Then number one. Number two, the another application possibly is that is your application seeking permission to withdraw the amount. Where is that? That application is which page it is? Three applications have been disposed of.
That also in compliance of the order of the Honorable High Court. As well, you can upload it.
You have to approve. Where is that application? Page number?
Just only.
There may be 259 kind of
259.
Thank you. 259. Very good.
Yes. I may require to hear both the Banerjees at length. Before that, now these are the very narrow, but the legal impact is very wide. If we formulate, as I have gathered from his submission, that there are two applications of his client in effect. Other I am not concerned about, Order 21 Rule 97. Addition in execution case. Secondly, permission to allow him to withdraw 1/9 of the occupational charges. can I gather that for the other rest portion you don't have any objection?
No, I don't have any objection. That is the reason I said that my prayer is now very limited.
There's only one relevant date I will be inquiring from you. This is a transfer in your favor. What is the date?
30th April. Transfer in my favor. That's the date is 15 March 2011.
15th March
2011.
The suit ultimately decreed when?
The suit decreed on 31st January 2008.
2008. No, decreed ultimately means decreed when the second appeal.
Second appeal, that is on to 23rd 29th March 2023.
29th March.
When it is 29th March 2023. Here is the judgment. I have a copy of the judgment.
Yes. Therefore, what is the nature of this transfer?
Transfer, that is
transfer penalty?
Of course.
Transfer penalty?
Yes.
Before you start your argument, I will be requesting you to consult 2-3 provisions of. Because I want to know from you what is the legal position would be there. As well as from you, sir. So this is transfer penalty. Your purchase is on 15th March 2011 from, this is Badrinath Infrastructure Private Limited. Your vendor, so far I recollect, it is advantage or disadvantage, I don't know, because factually it is still vivid in my mind that Badrinath at one stage of proceeding wanted to add itself in the suit, failed. My first query from you, if your vendor failed to get himself added in the suit, whether being a purchaser, you can be added in an execution case arising out of such suit. This is the first question. I do not want the answer instantly. Secondly, please take section 109 of the Transfer of Property Act. First of all, it may relate to rent, but I will take you to the occupational charges also. Proviso to the 109 puts a restriction on the transferee of to claim rent due before the transfer. Next question will come to you, Junior Bandobhat. Please take note of it. Yes. So, this is a restriction on claim of rent, whatever due prior to your transfer. Now, if we put it the other way around, occupational charge is not in that sense a mean profit. Please consult section 2. Hmm. 17 is 2 subsection 12 of the Code of Civil Procedure. Because there may be a breach between mean profit and occupational charges. Sometime it has been sought to be argued before the civil code that when mean profit is to be determined under Order 2012, these courts, occupational charges cannot be fixed on the guesswork or on the other materials. So there is a definition of mean profit. There is a procedure prescribed under the Code of Civil Procedure under Order 20 Rule 12, I suppose. 12. Realization of that mean profit. 12. An inquiry has been contemplated. If you read all this, you will be finding that there third parties have been excluded. If that be so, in a case of occupational charges, you know better than anyone that this is a concept which has been developed by different judgments. Starting from before Attaran, the division bench of our court in Attaram, possibly. Before this Atmaram, that was the division bench of. There, the concept of these occupational charges and the date of that was determined. This was. I'll be supplying you the judgment. There, in all cases, this is between the person in occupation. Mean profit is what is that you, after the decree, you are in wrongful occupation. It is prerogative of the landlord. Now, if you come to the definition of landlord under the 56 Act, these are the things you have to satisfy me to have 1/9 share. Addition that I will consider in view of your Order 2197, whether at all necessary or not. But if you define definition of landlord, if you go through that, it will be easier for me to go on.
Therefore, your lordship's query, if I have understood in the way that leave aside the order and etc., whether I am entitled to get 1/9 occupational charges at all or not on merit.
1/9 means 1/9,
whatever it may be.
Whatever it may be.
Whether I am entitled to get in view of the provisions of the Transfer of Property Act, mainly Section 109.
Again, I'm telling you that another hurdle may come in your way because it is a 56 Act.
তোরা এত কথা বলিস না, দরজা বলছে তো, তোরা তো এখানে বসতে থাকা উচিত না, দরজার চেয়ারে বসতে হবে।
2D
2D of transfer property.
West Bengal Premises Act of 1956. Is there any privity of contract? I'm exhausting myself so that I
have got your process point.
And lastly, what you have acquired? You have acquired 1/9 share. Whether your sale is hit by lease or not, 52 will come into operation or not, Transfer of Property Act. That is to be for them to take the objection or not. But fact remains, if this puts an embargo on your client that your purchase to claim the area rent as well as you may have on the proof of the perfect title, acquisition of perfect title, you may have a claim against the other co-sharers who are, and it has been held to be, they are entitled to maintain a suit for eviction against their tenant, entitled to, they have been defined as a landlord, affirmed as a landlord. That is why I am showing the definition of landlord, entitled to receive the rent. Obviously, and as a corollary of it, they are entitled to receive the occupational charge.
Correct.
Right? So, if they are entitled, your remedy may be if you have any by dint of your purchase against them by your other reports, not in the execution case. This is my prima facie view.
Other reports I have a
very well.
I will consider all this and I will come back. There's no problem. I will consider all this next week.
Tell me when.
Next week.
Before vacation, after vacation?
No. Next week, Tuesday or Wednesday.
Sir, see the list.
Only Tuesday. After Wednesday, I will not be here. Vacation for. I think they are having an urgency. I can't say after vacation.
Mr. Banerjee, what is the next date fixed in the execution case?
19th of September. 19th of September. And as it is done minor, since minor not from the service but from the bar, whenever a matter is pending with the trial court, I did also send the junior state. I could pay matter.
No, there is an interim order is there in this matter.
What is
Interim order passed. Yes.
No, not staying the execution case there.
Not staying the execution.
No, I am clarifying. Pendency will not deter the execution court to proceed. This is regarding money and addition.
Money has nothing to do with that execution. You are absolutely correct.
Under the pending final disposal of the revisional application, this court of the view that the degree holders are entitled to withdraw the amount as directed in the second application. Leaving aside 1/9.
That interim order will continue.
Leaving aside 1/9.
But pendency we cannot deter the executing.
I am not, let me I'm very candid to your lordships, Millard. Then only 1/9, sir, I am concerned. I am not concerned about it.
Tell me when after vacation. I formulated the question.
After the vacation, then Millard, first week of November or second week.
The execution is continuing. Very well. If possible, before vacation, why not?
First week you will be here.
First week of
November you will be here.
Yes, I will be here.
8th तक तो शुक्रवार है 2 p.m. 8th.
Not on Friday, Thursday and Friday.
Thursday and Friday you have difficulty.
No, they say GPC and the walk-up committee.
6th of Wednesday? 6th of November.